Hello, everyone, and welcome. Thank you for joining Foley and Lardner for today's program titled How Automotive Companies Can Prepare for Upcoming Changes to International Trade, Labor, Environmental, and Safety Rules. If you have questions about any of today's topics, we invite you to type them into the Q&A widget on the left side of your screen. We will be answering questions at the end of the program. A recording of this presentation will be available on Foley.com within the next few days, and a copy of today's slides can be found in the resource list on the right side of your screen. If you experience any technical difficulties with the webinar platform, please refresh your browser or see the webcast help guide on your screen, which is designated with a question mark icon. For attendees seeking CLE credit, a CLE code will be announced during the presentation. Please enter the CLE code in the polling slide that will appear on your screen. Attendees seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to answering the polling question. A copy of this form is also available in the resource list on the right side of your screen. Please email your completed form to jdelatore@foley.com following the program. CLE certificates of attendance will be distributed to eligible participants approximately 8 weeks after this webinar via email. As a final note, there is a short survey located on the right side of your screen. We would greatly appreciate your feedback on today's webinar. And now, I will turn it over to Greg Husissian to begin today's program.
Okay, thank you, and good morning to everyone. Once again, thank you for joining our webinar on how automotive companies can prepare for the upcoming changes to the international trade, labor, environmental, and safety rules. So that's a long title, but it reflects that the expected changes in the new administration are likely to be far-reaching. We've been receiving a lot of questions about how the regulatory environment is going to change in the new administration, and not surprisingly, a lot of those have been coming from companies in the automotive industry. This isn't surprising. The automotive industry throughout its supply chain is heavily regulated. It is often international in focus. It's seen the biggest impact from the ongoing international trade war, and it has, in many ways, the biggest stake in knowing what's going on in the new administration. So we thought we'd put together this information session to help you navigate what we see as the new rules and to stay ahead of the curve on these topics. So it's my pleasure to be introducing and welcoming our speakers today. I am Greg Husissian, the chair of the Foley and Lardner International Trade and National Security Practice, and also the co-chair of the automotive industry team. I'm here with Mark Aiello, who is also co-chair of our automotive industry team, who will be acting as today's moderator. Our speakers today are across a wide range of Foley practices. I will be presenting with Jen Lane Scott, who is an associate in our Washington, D.C. office, and will be presenting on international trade topics in just a few minutes. Also speaking today will be Jeff Kopp and Felicia O'Connor from our Detroit office, who will be addressing the labor and employment issues that are facing employers in the automotive industry in 2021. After that, Pete Tomasi and Amanda Beggs, who are in our Milwaukee office, will be addressing the new environmental policy, the regulations to watch, and the environmental enforcement priorities of the new administration that we see on the horizon. And then finally, Chris Gregorian, who is a partner in our Washington, D.C. office, will be discussing the various vehicle and safety regulations and enforcement activities we can expect under the new administration. So with that, let us begin today with our webinar on the likely priorities of the new international trade team, the enforcement priorities of the new regulators, and best practices for adapting to the new USMCA rules, which are the topics that we are getting the most questions on from our automotive clients. So as I said, I'm here today with Jen Lane Scott. We work together on a wide range of international trade matters, including customs issues, CFIUS filings, dealing with the export controls and OFAC regulations, and of course, dealing with the international trade issues, including the international trade war. So the central questions that we are going to be talking about today, they kind of center around the import side, which is the side that is impacting the automotive companies that source from, sell to, and operate abroad. That doesn't mean that the export side doesn't matter as well, because the things like export controls and the OFAC sanctions and dealing with Iran and Cuba and things like that are certainly going to be enforcement priorities. But early on, what we see as the biggest changes are often on the import side. So we thought today we would concentrate on 4 areas, including how automotive companies can anticipate dealing with importing goods that are impacted by the international trade war and the prospects for that continuing, how to deal with the importing goods and the heightened customs compliance obligations that have become so important in the last couple of years, in part because of the high tariffs due to the trade war, how to deal with importing goods from the USMCA region and adapting to the new regulations, and then also looking at the impact of the new U.S. government supply chain expectations, which are enforced at the border but can have wide-ranging impact on how companies manage their global supply chains. So all of these topics for this audience, for the automotive sector, and my colleague Jen Lane is going to start by talking about the international trade war. So
Perfect. And thank you all for joining us this morning. I'll talk a little bit about the international trade war, which over the past 4 years has really been colloquially dubbed the Trump trade war. But so far in what we've seen with the Biden administration, there seems no signs of stopping this trade war, at least initially. The administration has made it very clear that their first priorities and focus are really on both economic recovery and the COVID-19 pandemic. But there have been kind of indications that President Biden feels strongly about keeping these trade tariffs and this kind of trade war intact. In fact, President Biden issued a proclamation at the very beginning of his presidency regarding the Section 232 duties for the UAE, which had been taken away by President Trump at the end of his presidency, and President Biden reinitiated them based on kind of his understanding that they were effective, they were working, and it was something that was going to be important for his administration to deal with and determine on its own. With that, his administration so far has discussed how they are going to focus on kind of reversing this unilateral approach. We got a little bit more isolationist in our policy, and we're really going to see a lot more engagement with our allies for this trade policy under the Biden administration. However, with that, he still has emphasized a big focus on reinvesting in the American economy and really buying American. So it's going to be an interesting balance for the Biden administration to kind of leverage both sides of that coin. Additionally, we have the new U.S. trade representative who was just confirmed by the Senate Finance Committee. And so Catherine Tai, she's been a longtime trade individual, so she's really well equipped to handle the current situation and see outs, especially with what is going to go on with China. And that's obviously going to be a very high priority for the Biden administration. Both the president and Catherine Tai have kind of talked about these 3 main items being environmental, ending unfair trade practices, and really focusing on renewable supply chain, which Greg is definitely going to touch on a little bit more. But she seems to be a very strong pick for a more inclusive trade policy, but it's definitely going to be very interesting to see how this kind of shakes out. Next, kind of how the implications of the continuing trade war are going to potentially impact any of your companies. So President Biden has really emphasized so far a focus on resourcing and U.S. manufacturing, but it seems that it'll be a more well thought out and comprehensive or nuanced plan than prior. But there's going to be, like I said, that more engagement with allies and other countries looking for areas of common cause, whether that is with countries that we typically deal with on a friendly basis, or perhaps some others like China, seeing what kind of common ground we can find. However, for now, those Section 301 tariffs are going to remain in place against China, and only kind of a verifiable long-term deal is going to satisfy both sides and the bipartisan concerns. So both sides have become very clear kind of stake that China needs to be dealt with in terms of the trade war, but we're still going to figure out the nuanced way to approach it with this administration. Additionally, the Section 232 duties on aluminum and steel so far are going to remain in place. And then, as I'm going to touch on a little bit, there's really a big emphasis still on the customs compliance and supply chain due diligence. Additionally, if there's any foreign direct investment in the United States, that's going to, there's some revamping of the CFIUS process, so there's going to be more mandatory disclosures with that foreign investment. So another kind of thing to think about in the realm of international trade. With that, I'm going to speak a little bit on the importance of customs compliance for your companies right now. So Customs has rolled out the Automated Commercial Environment, or ACE system, which, while is very useful, it's also kind of a tool for Customs to be able to do more targeted reviews and go aggressively after importers for the underpayment of duties. So they're able to more manipulate the data in a way than ever before and see how that the maybe lack of paying import duties is impacting the customs regime. So it's something to just be mindful of, especially when you are filling out your customs form 7501, that kind of importing form. It's important and really critical to your business that those are accurate and correct. Additionally, we're seeing more of those customs forms 28, request for information, and forms 29, notice of action, being sent out to companies, and it's very critical that you have those properly responded to for your company to make sure that there's no further kind of inquiry or investigation by Customs. Further in state, especially the Section 301, 232 duties, Customs compliance is really key, making sure that you are implementing a broader policy than potentially ever before. Customs is now even holding and stopping imports if they're concerned that those imports are the product of human trafficking or forced labor, and they don't really need a good reason to do so. It's just kind of a right that Customs has taken based on the current regulations in place. There are also, of course, free trade agreements and preferential trade legislation, which you need to pay keen attention to because they vary across the different agreements. So those also increase the odds of audit from Customs and potential costs of non-compliance. So how can you protect yourselves in this kind of ever-changing customs regime? What we really recommend is a key and clean customs policy and manual. By having that, you have one line of defense to a customs audit or investigation. Going through the customs classification index and perhaps having an outside audit, customs audit come in to value your products. And the declared value is going to be very helpful in terms of stopping kind of issues before they start. Coordinating with your customs brokers and freight forwarders is also going to be very key. However, they are not your compliance policy. You still need to make sure that as the importer of record, you're going to be the one on the hook. So you need to be the one to ensure everything is properly done and filled out. You can evaluate your other claims, making sure that you're paying all of the proper duties or the proper information based on the USMCA, the free trade agreements, anti-dumping, countervailing duties, consider when you are the importer of record. And another way that we've been helping some of our clients is conducting internal customs compliance audits, having more training, and having those procedures in place to kind of help inform the customs regime as to what's going on with your company for those informed compliance letters. So now I'm going to hand it back to Greg to talk a little bit more about that USMCA.
Yeah, to underscore what Jen Lane said about customs enforcement, we have 9 customs enforcement actions going on right now. 5 of them came because of a result of an initial customs query, whether it was a Form 28 or Form 29. In one case, a request for a risk assessment survey. They're really getting good at mining the data that they have. And in one case, they told us that you may wonder why you're here. It's because we did a survey of customs information and 13 companies popped up as having anomalies, and you were one of them. So that's really important to underscore just how good they've gotten at ferreting out potential issues. Now that, of course, overlaps with the USMCA because customs also enforces the USMCA requirements. And the USMCA affects the automotive industry more than any other one just because of the amount of trade they do and because there's a lot of specialized rules for them. It's similar to the NAFTA, probably 90 to 95% the same as NAFTA, but the changes in the details are huge and impact the automotive companies, especially with regard to the regional value calculations, the labor value requirements, and there's a lot of HTS-specific rule changes. So it really does require you to take that index of classifications that every company should have if you import a lot, as Jen Lane mentioned, and then consider what the rules are. The customs implementing instructions, unfortunately, only came out in April of 2020, and they leave a lot of gray areas. And the other problem with the USMCA is you really have to involve your supply chain. If you don't have good supply chain cooperation, you're not going to have good USMCA, FTA preferences calculated correctly, and that can potentially lead to a lot of problems and penalties at customs. The USMCA requires a top-to-bottom review of your calculations, of your import compliance in general, of your supply chain compliance, making certain that the people in your supply chain are handling the rules correctly. It is very, very important to view this, however, as part of your global customs compliance. You do want to have an up-to-date and updated customs classification index to ensure that you are applying the rules properly for all of the goods coming in. You do, as I said, have to involve your entire supply chain. And you need to go beyond the certifications. Just because someone gives you a certification doesn't mean that they've understood the rules correctly or applied them correctly. And if you're the importer of record, that can rebound to hurt you. So you have to really delve into how accurately your supply chain is handling the rules. This is a good opportunity to update your general compliance, particularly if you haven't, and training. If you haven't done that in the last couple of years, this is a good reminder you need to do it. And don't assume. A lot of companies come in and they take the NAFTA as the baseline and say what was changed. But in the current environment where customs is so aggressive, then you don't want to just assume NAFTA compliance was good. You really kind of want to do zero-sum budgeting. In terms of the other item that we wanted to talk about was the supply chain management. There's a new executive order from President Biden. One of the first things he did was addressing supply chain management and signaling a clear interest in monitoring, revamping supply chains and reshoring. But this is against a backdrop of the U.S. government pushing companies to actively manage their supply chain. There was a 3-agency advisory regarding North Korean forced labor and the hidden sourcing of goods, which has a lot of compliance expectations for supply chains in general. Customs, we're seeing they're being much more active in blocking goods that are arguably the products of forced labor or human trafficking. We've now seen 7-figure enforcement actions, such as the one against Elf Cosmetics for importing completely unknown to them false eyelashes that they purchased in China, but that had initially been sourced in North Korea by their Chinese supplier, which underscores how companies can be killed by their supply chain, even from actors they aren't really even thinking about. And then the Xinjiang sanctions that came out at the end of the Trump administration, which effectively upended the cotton and the tomato industries, because that area in China is the main source of those goods worldwide. I mean, all of these things, if you put them together, indicate the U.S. government expects you to have good supply chain management, know your suppliers, know your business partners, and treating them as risk factors. Some of the key things that we see people should do, as I said, know your business partners, know your supplier standards and policies. If you don't have a supplier or vendor code of conduct, you should be looking into that and putting one in place to protect your organization. Terms and conditions and certification requirements aren't the be-all and end-all, but they're certainly one important piece of the compliance puzzle when it comes to your vendor management. If you don't have a human trafficking forced labor compliance policy, that's a good idea given how customs is acting. And consider integrating supply chain management throughout your compliance infrastructure, code of conduct, and compliance policies. And remember, this comes up not just with regard to customs, but also OFAC concerns, which also can arise for both imports and exports. So again, we're concentrating on the import side, but we don't want to slight the export side as well. So that brings our presentation to the end. I suspect we've got some audience questions. And of course, if you have confidential items or would like to arrange a one-on-one discussion, just let us know and we'd be happy to talk about how these things impact your organization in particular.
Okay, Greg and Jen-Lane, if you can summarize, what proactive steps do you anticipate companies will need to take in order to cope with the trade war?
Yeah, that's a great question, Mark. We've been working with companies to do a few different things. One of them is tariff engineering. So we've been trying to figure out the most appropriate place for companies to be able to source their goods, that their goods are then either, not from China, or their products can have different country of origin components. That's something that we've been working a good bit with some of our clients on. It's been very successful. Another option has been working on the exclusions, and currently not in play, but when the Section 301 exclusion process was live, and we'll see what happens next in the Biden administration. So helping our clients apply for those exclusions as well has been something that's proactive and been very useful.
Yeah, and one thing I would add on that is we've seen tariff savings of up to $60 million a year for some of the companies that we've helped out on this. So managing the tariff strategies and making certain that you're not overpaying your Section 301 duties, whether through management of the value or being certain you're on the correct list, can really pay off in terms of not just general compliance, but putting money back on the bottom line.
Great. Thank you, Jen-Lane. Thank you, Greg. Next up, we have Jeff Kopp and Felicia O'Connor, who will present on labor and employment.
Good afternoon, everyone. And my name is Jeff Kopp. I'm a partner in Foley's Detroit office. And Felicia and I are going to talk to you about some labor and employment issues that we think affect automotive clients, largely COVID-related. And let me start by talking about some COVID-related leave issues. And I'll start with the changing landscape. It's fair to say that COVID-19 has had a significant impact on the way that everyone's lived and worked in 2020. And I saw some interesting statistics on LinkedIn regarding employers, and I think it applies to automotive companies as well. But 46% of businesses said they still hired in 2020, and 73% of the respondents said that remote work is going to become the standard. And so we saw a major shift in how work was being done remotely, and that has real implications for your workforce, particularly with respect to leave. But I think 70% said that believe that they could do their jobs remotely on a full basis. And so with very limited morale issues, we see that only 6% or 7% of at-home workers are saying that they have low morale, or 7% said they were struggling from working from home. But automotive manufacturers who actually have employees working in the workplace where work can't be done on a remote basis, a third of the workers said that they feel uncomfortable about how their employers' at-work safety measures are shaping up. And that has implications for complaints being filed with OSHA and state agencies that enforce safety. And 26% of on-site workers were saying they had low morale, which leads to leave issues. So these statistics are important because they show that remote work might actually be favorable for the climate and people that are working on site might have more safety related complaints and issues. Let me talk about the FFCRA issue briefly. So the FFCRA was adopted in connection with the CARES Act. It's the Families First Coronavirus Response Act. Applies to really smaller employees, less than 500 employees, and it provided for expanded FMLA and paid sick leave for employees for COVID-related absences or because of school closures primarily. And the law was set up to provide a tax benefit, a tax credit for employers that provided leave in those situations. The only thing that we'll report here is that the law expired in December 31st of 2020. However, the tax credit provision of the law was extended to March 31st of 2021. So while employers don't necessarily have to provide leave anymore under the Families First, the Coronavirus Response Act, they can do so voluntarily and take advantage of those tax credits. And if the employer chooses to do that, they can either choose to provide the expanded paid sick leave, which is that 2-week portion of the leave, or they can provide expanded family medical leave for the additional 12-week period if they chose to do that. So FMLA and ADA implications, we're seeing a lot more issues that come up in this area. The FMLA, we're not really seeing any case law yet because it's only been a year since coronavirus came up, and so we're not really seeing the cases proceed through the court system that quickly. But we are advising a lot of employers on the implications of FMLA. And I can tell you that not all absences are necessarily FMLA protected. And employers really should resist the temptation to designate all absences as FMLA leave, because that could give rise to situations where employees claim FMLA interference with later leave that they try to take if they exhausted their FMLA for leave that really should not have been counted as FMLA leave. And conversely, by offering FMLA protections when the FMLA doesn't apply, that could provide employees a right to reinstatement that they might not otherwise have. So I think it's really important that the employer work with counsel to determine whether certain types of leave are going to be covered by the FMLA. And I'll just give you one quick comparison. If an employee is hospitalized because of COVID-19, then that would be covered under the FMLA. But if they were saying they wanted to take leave to visit an aunt or an uncle who is in the hospital for COVID-related leave, and I don't even know that they'd be able to do that, but if they were able to take leave for that purpose, it would not be FMLA covered. We're also seeing a lot of issues with the ADA, and primarily in the context of employees requesting ADA accommodations. And so those have to really be handled on a case-by-case basis. The employer has an obligation, as most of you know, to engage in an interactive process with the employee to make sure that if there are reasonable accommodations, such as telework, that could be provided to that employee, that it be done, that would be provided to them. So early on in the pandemic, we were having a lot of questions that came up with employees who were just afraid of coming into the workplace because of COVID, and whether or not that triggered an ADA accommodation just the fear of having COVID, and very well might if someone has depression or anxiety related to that condition. So it's something we'd want to work through. And finally, keep in mind that there may be other local quarantine or other leave requirements. A lot of states have paid sick leave laws like Michigan, and you should be attuned to that. The CDC guidelines still apply, even though they've punted to local health authorities with respect to, and states with respect to orders. So each state really governs how many days that somebody should be quarantined. Early on, it was 14 days the CDC was recommending after contact with a person with COVID, and then that changed to 10 days without testing, or 7 days if the individual receives a negative test. So just keep in mind that those things are changing, and they might still change as we have vaccinations. And so that takes me to the next topic, which is probably the topic of the day, and that is vaccinations. It's a topic that's on everybody's mind as these become more available. And the question that's come up is, should employers mandate that their employees receive vaccines before they can come back to work? And so the EEOC weighed in on that, and they said, yeah, an employer can require or encourage vaccinations. But in order to do that, the employer has to comply with the Americans with Disabilities Act and Title VII. And to do that, they have to, for Title VII, there could be employees that have religious reasons why they can't take a vaccine or don't want to get the vaccine. And the employer has to be cognizant of that and make certain accommodations for people who might have religious objections. And the same thing with the ADA. There very well may be people who have medical conditions that prevent them from getting a vaccination. And so the employer can't necessarily discriminate against someone because of their refusal to get a vaccine. And you have to really then analyze whether allowing that person to come in without the vaccine prevents a direct threat to themselves or to others in the workplace. That's an analysis that's done on a case-by-case basis. Keep in mind that vaccinations still are not really largely available to all automotive manufacturers at this point. Some, in many states, it's opening up. In Michigan, we're now at 50 years old and over. And if employers have a presence in certain jurisdictions like the city of Detroit, then the employees there can obtain vaccines. And at the Chrysler plant, I think in Detroit, they are actually administering those vaccinations from the workplace to make it easier for employees to get that. There has been some opposition from employees on getting the vaccine. And so you should keep that in mind, that could be a potential. And you don't want to be in a position where you have to terminate everybody who refuses to get the vaccine, because sometimes the numbers we've been hearing are pretty high. And then finally, you have to keep in mind the ADA implications. Again, there may be certain people that can't get a vaccine or are requesting certain accommodations, and we want to handle those again on a case-by-case basis. The key thing is for you as an employer to make sure you have a good written policy, a COVID-related policy, and that you're enforcing the protocols that are in place by your states. In Michigan, we've seen a number of our clients be cited by OSHA for not a number, but a few, for having potential violations for not reporting COVID-positive employees, and also by not enforcing mask and social distancing standards. And so that takes me then to incentives. I think that probably the preferred route that we're seeing most clients take right now is that they're encouraging vaccines to be done rather than mandating them. And that would include educating employees about vaccines, making vaccines available to them in the workplace, covering the costs of the vaccine, and perhaps providing some kind of incentive like money or gift card. Keep in mind that if you're in a union environment, that you have to bargain with the union and get their union's acceptance before implementing that change. And then the last question is there may be ADA considerations if an employee can't get the vaccination because of either a religious issue or a medical condition that prevents them from getting that, and they should probably be still given that same incentive even though they can't actually get the vaccination. So with that, I'm going to turn this presentation over to Felicia, and she's going to pick up some additional topics. Thanks.
Well, hi, everyone. I'm just going to talk a little bit about some changes that we're going to see coming because of the change in the administration. With the new Biden administration, there are several elements of changes that we know are coming, and then likely some more that are in the works or that are planned down the line where they're not really being implemented yet. So I think the overarching theme really is to pay attention to the changes because they're going to be happening, and to keep up to date of what the plans are, what's in the works, whether things are passing or not passing, because every day things are changing. And one good example of that is the federal minimum wage. So changing the federal minimum wage to $15 an hour is a goal for progressive Democrats, is a stated goal of the president. And originally, when the coronavirus relief package was proposed by the Biden administration, a $15 federal minimum wage was included in that, and it was included in the original bill. As the bill worked its way through Congress, the Senate parliamentarian actually looked at the rules of what could be included in a budget bill and ruled that this aspect of the $15 federal minimum wage could not be included. Then there was a provision where there was a proposed amendment to the bill to add that $15 minimum wage back in. It ultimately did not pass. And I think there was concern and stated concern over from some senators who had previously supported a $15 minimum wage and say in theory that they do support a $15 minimum wage, that right now, considering the recovery of small businesses, especially restaurants and others in retail, that a $15 minimum wage right now might be more harmful to those small businesses while it's still a long-term goal. So I think this is illustrative of the fact that we all anticipate that a $15 federal minimum wage is something that is desired by Democrats who now obviously have both houses of Congress and the presidency, and that there will be efforts to get this passed. And it's just something to keep a close eye on, because as things work through various bills, whether it's included or not included, as you can see by this, gets somewhat complicated. So something to keep an eye on. At this point, there is no $15 federal minimum wage in the coronavirus relief package because of these issues that I discussed, but it is possible that it is coming in some other type of form in another package or as a standalone. So something to keep an eye on as the administration continues. Another change that we will see is changes to the rules that govern whether folks are classified as independent contractors or employees. As we saw in the Trump administration, there was a proposed rule that was finalized, and it was finalized right before the inauguration of President Biden and was set to take effect in March. The standard of that new final rule was widely considered to be employer friendly. One of the first actions that the Biden administration took after the inauguration was to put a hold on all that finalized rule and some other finalized rules from taking effect. So now that rule that was going to be employer friendly has been halted. It will not take effect in March this month. And instead, I think what we will see is likely a new proposed rule that has not been proposed yet that will mirror something like the ABC test, which is what Biden has said before the election that he endorses. And we'll talk a little bit about the ABC test, but in the meantime, while the new final rule that was implemented under the Trump administration has been put on hold, then really the standards are just reverting back to what would be used at the various agencies, and there are several tests depending on where you're applying it, and states have various rules as well. So it will revert back to the system that we were all using to determine whether a contractor is an independent contractor or an employee prior to the Trump final rule. So what we anticipate is a possible new proposed rule under the ABC test, which is widely seen as being employee friendly. And that test, as defined by the California Labor and Workforce Development Agency, is that the default is that an employee is an employee unless they meet all three of these elements. One is that they're free from the control and direction of the hiring entity in connection with the performance of the work. both under the contract and in fact. So just having a contract that says that they are free from the control of the employer and that therefore they're an independent contractor, that's not going to be enough. It has to be the facts on the ground bear out that they are actually free from the control of the employer. The second element is that the worker performs work that's outside the course of the employer's regular business. So if you have employees and independent contractors performing the same work, that's going to be a problem under this test. And those folks will be determined to be employees because they're not meeting the second element. The third is that the worker is customarily engaged in an independently established trade, occupation, and business of the same nature. So there we're looking at folks that may have their own business where they are providing these independent contractor services to a number of different employers, where you get into a little bit of trouble and an employee may look more like an employee. In this case is where you have someone who's really only working for one employer and performing services that aren't sort of traditionally thought of as something that a contractor would perform. So this is the ABC test. It's not implemented at this time. It's the test that the Biden administration has said that it prefers. So we expect that at some point we'll see a proposed rule, and then that will obviously work its way through the rulemaking process, which can be somewhat lengthy. So no immediate changes, but again, something to keep an eye on, changes that are coming down the line in this administration. And finally, what I'm going to talk about just briefly is changes to the NLRB. So the board is made up of 5 members. 3 are from the president's administration, 2 from the opposing party. So we obviously have had a change in the party in control in the presidential administration. And so the previous board was 3 Republicans, 2 Democrats. That's going to change to be 3 Democratic members and 2 Republican members. The issue is that it's not an immediate change because the members serve certain terms that have a specific length. So the first Republican term expires this August. We expect that the Biden administration will be very swift in naming a replacement for that member. And then it will change control from 3 Democratic members to from 3 Republican members to 3 Democratic members. The agenda under the board with this new control, we expect it to be similar to what we saw under the Obama administration, which is quickie elections that, if you're not familiar, obviously have much shorter time frames in terms of how an election runs, hence the name quickie elections. Second, the standards for joint employer and independent contractor rules will become more employee friendly. And again, we'll see an aggressive view of handbook policies, employee handbooks that again will be seen as more employee friendly versus employer friendly. And in the meantime, President Biden has also appointed a new general counsel for the NLRB. The general counsel is in charge of investigation and prosecution and heads up all of the regional offices of the NLRB. So to the extent that they're under the previous general counsel were various priorities emphasized under the appointee from President Trump, those will change now that the appointee was appointed by President Biden. For now, it's just an acting general counsel. So at some point, he will have to nominate someone officially to be the general counsel, and they'll go through a confirmation process. So those are just 3 instances of employment-related issues that we see changing under the Biden administration. It's certainly not an exhaustive list, but we wanted to just give you a sense of the fact that things are changing, and the best course really is to kind of keep your ear to the ground and understand what these changes are. Things are moving quickly. You may hear that the $15 minimum wage is going to be implemented, then it's pulled back. So consult your employment counsel and just keep your eye to the news to see all the changes that are coming.
Felicia, Jeff, now that things are starting to open back up a bit and companies are considering business travel, are there current restrictions or quarantine requirements on employee business travel?
Yeah, we've received that question from a number of employers, and right now there are only requirements as to international travel. So the CDC has implemented a requirement that any arrivals in the U.S. through flights, through airplane travel, have to have a negative test within 3 days of their departure. So if you do have folks who are engaging right now on international business travel, one thing to keep in mind is that they're going to to need that negative test to be able to board their flight in the foreign country to come back into the US. And that can be tricky depending on where they're traveling, depending on the length of time to get your test results back. You know, if you take a test one day before, are you going to be able to get your results within 3 days to get on the plane? So something to keep in mind in terms of international travel. With domestic travel, there are not CDC requirements as of now. There are recommendations in terms of what travelers should do, which is take a test in the 3 days before you travel, and then some isolation when you reach your destination, and you can take a test on your destination to speed up that recommendation of quarantine when you get back. But the thing to keep in mind really for domestic travel is that various states have differing rules in terms of quarantine periods that may be imposed. A state like Michigan currently does not have any requirements for domestic travel, but a state like New York does. If you are arriving in New York from a state that is not contiguous with New York, and there are various rules for essential workers. And so what you want to do is if you have domestic travel for your employees taking place, make sure you're very familiar with the local rules and the destinations that your employees are going to, because they vary state to state.
Great, thank you. And what are your recommendations on how employers can maintain a stable workforce if they do not mandate vaccinations?
Good question, Mark. I can take that. And so, I think that as I mentioned before, educating employees about the vaccinations and as they become more widely available, that would hopefully stabilize the workplace and maybe reduce absenteeism, I think, which is a big concern of some of our clients. And then, and really just making sure that employees are comfortable with the protocols that have been put in place from a safety perspective, and that employers really are enforcing the things that they're saying that are in those protocols, things like social distancing and mask wearing. Most of the citations that we've seen from MIOSHA, for instance, have really focused on the fact that employers aren't requiring people to wear masks in the workplace, even though they put up signs that say mask wearing is required. If employees are walking around and other employees complain about that to an enforcement agency like MIOSHA or other states' versions of that, then employers could be subject to penalties. So I think stabilizing the workforce will, by one, really encouraging vaccinations, and two, really letting employees know that employers are taking steps to ensure their safety.
Great, thank you. Good presentation. Thanks, Jeff. Thanks, Felicia. Next, we have Peter Tomasi and Amanda Beggs, who are going to speak concerning the impact of the new administration on environmental regulation. Thank you.
Hi, thanks, Mark, for that introduction. As Mark said, I'm Amanda Beggs, and I'm an associate in the Milwaukee office, and I'm here with my colleague, Pete Tomasi, who focus on environmental matters. So just jumping right in, the first thing we'd like to sort of touch on here is some trends we're seeing from a policy perspective from the Biden administration and Biden's EPA, both from our matters we're working on and just Biden's recent executive orders and his public statements. So some initial steps that we see from the agency are primarily to reverse some of the key deregulatory actions of the prior administration in the mobile source space for the automotive industry and for off-road equipment and other applications. A couple of examples of this that Pete will touch on in a minute are the anticipated rollback of the Safe Vehicles Rule, which weakened the CAFE standards that the Obama administration put in place for fuel efficiency standards, and then also the anticipated reinstatement of a California preemption waiver for California setting its own greenhouse gas emission standards and implementing a zero emission vehicles program that the Trump administration had rescinded. We anticipate that will be reinstated. Another significant focus that we're seeing is just a focus on two-type emissions from a greenhouse gas perspective, and then also a greater focus on zero emission vehicle programs. We've also seen a lot of information and focus on environmental justice and the social cost of carbon in rulemaking. So what does that mean? When we think of environmental justice, we often think of the disproportionate impact that emissions from vehicles might have in a low-income community, which is certainly something that EPA will consider in rulemaking. But there's also a flip side of that, looking at the cost that a rule may have on low-income communities. For example, a number of years ago when EPA was considering a ban on refrigerant cans under the SNAP rules for having ozone depleting substances, EPA looked at who used those single-use cans and how that might affect certain users, and EPA found that it was more individuals in low-income communities that were doing do-it-yourself auto repairs that were using those types of single-use cans. So they looked at that and decided to kind of scrap that rule since it would have a disproportionate impact and had environmental justice concerns. The other thing we anticipate that EPA will be looking at in its rules, upcoming rules, is the social cost of carbon. At the end of February, Biden reinstated an interagency group to evaluate the social cost of carbon, really to monetize what that cost was. And set it at what the Obama administration had set that monetary value at. The Trump administration had set it at a very insignificant level. And so we anticipate that cost will be factored into the cost benefit analysis and rulemaking by EPA. And just yesterday, actually, 12 states led by Missouri have challenged the actions of that group. And so that's being litigated in the Eastern District of Missouri right now, and is one of the first sort of major challenges the Biden administration has faced from an environmental perspective. And then overall, we just think that there's going to be increased enforcement at the federal level by EPA and also by the California Air Resources Board, which is very active in this space as well. So with those initial policy trends, I'm going to turn it over to Pete Tomasi to talk about some of the rulemakings we anticipate.
Thank you, Amanda, and good morning, everyone. As Amanda stated, we have been looking at a number of potential regulations, and I think it's fair to say that the new administration has been very engaged on the environmental front with respect to mobile sources, and with respect to the safe vehicle rule, sort of the first key element, one of the number of regulations that President Biden signaled in an executive order that he signed in his first day of office would be reconsidered is that rule. So the Obama administration had issued basically a more rigorous set of greenhouse gas and fuel economy standards. The Trump administration rolled that back. And it is a high priority of the current administration to re-engage and raise those standards. With respect to a separate set of issues that comes under actually a different set of provisions from the Clean Air Act, but actually does have impacts for fleet operators and for especially for heavy-duty vehicle manufacturers, are regional air quality requirements for mobile sources. I think most people are familiar with California's sort of unique position under the Clean Air Act and its authority to set emission standards. But in order for states to achieve the compliance with the National Ambient Air Quality Standard for ozone, a standard that is set and reviewed every 5 years and incrementally has been lowered substantially since the 1970s. Every 5 years, states and other agencies in California, you have the regional agencies, have to put together plans to identify compliance with standards, and if an area is in non-compliance with ozone standards, they have to impose additional emissions restrictions. So these are things like anti-idling requirements that in some places have led to a push for alternatives to truck idling, battery packs, et cetera. A third tier of matters, and Amanda will get into this in a moment, are the potential for zero emission vehicle mandates and a similar regulatory push at the federal level to the ZEV requirements that are already in place in California, and that the California Air Resources Board and Governor Newsom have recently stepped up substantially on a path to a 100% zero emission target in the next few decades. The mechanism by which EPA would issue those regulations, I think, still requires some consideration, but it's definitely something that the Biden administration has again signaled is a priority. A second sleeper issue, in addition to sort of the impact of ozone regulations, are other chemical regulations that apply to up and down the supply chain, and that manufacturers may not be monitoring. They're easy to slip up on, especially when you have elongated supply chains that stretch across an ocean or across a continent. So as an environmental attorney, it's hard for me to get through a day without hearing about a class of very ubiquitous chemicals called perfluorinated alkylated substances, or PFASs. These are the compounds that form the basis for Teflon, for Gore-Tex. They are hydrophobic, they're lipophobic, they're basically flame retardant chemicals that have a lot of industrial uses. But within the last 5 years or so, they have been found in water, drinking water, and surface waters throughout the U.S. And US EPA is moving forward with regulating those compounds as a class. Another set of compounds to watch are approved refrigerants under US EPA's SNAP program, which Amanda had mentioned. That's a significant new use, significant new alternatives policy program that was originally put in place to authorize replacement refrigerants for the CFC compounds that cause stratospheric ozone depletion, and that were phased out under the Montreal Protocol. This is, again, a situation where the Obama administration had implemented a set of regulations. They were rolled back by the last administration, and the Biden administration has signaled it will put new rules in place. In addition, the US EPA has recently been authorized its first new authority to rule out additional types of refrigerants that it previously didn't have under the Clean Air Act. So refrigerants are somewhat surprisingly, becoming a somewhat hot topic as a number of requirements are phased in, and we see potentially a longer term phase out in the products themselves, and then the accompanying equipment used. So you need to redesign your compressors depending on the pressures used, and various other components related to those compounds. And there are other US EPA chemical regulatory provisions that have been implemented, that have been phased in under the last administration. This morning or yesterday, US EPA issued a stay of a rulemaking that was going to phase out a plasticizer and flame retardant compound when a number of manufacturers noted that they hadn't realized how common these chemicals were. So chemical regulations are sort of a fourth bucket to monitor. And finally, if when we go through zero emissions vehicles, we do see development of a push for hydrogen powered fleets, it is likely that US EPA may develop additional fuel-related regulations and potentially other emissions regulations for hydrogen burning internal combustion engines. And with that, let me hand it back to Amanda.
Thanks, Pete. Now we'll talk about a bit of the trends we're seeing with respect to enforcement. So EPA has identified mobile source enforcement as a national compliance initiative since 2015, and we anticipate that enforcement is just going to ramp up in this space under the current administration. There's been a number of new enforcement policies put out by EPA recently, one related to aftermarket parts and what EPA does and does not consider tampering under the regulations, emissions tampering. And EPA is also currently considering comments with respect to an aftermarket catalytic converter policy with a similar tampering focus. Also note that there is a new and mobile source civil penalty policy that EPA put out at the end of January. We haven't seen any matters settled under that policy yet, but we do note that it is much different than the policy that was put out in 2009. There's different categories of alleged violations and different penalty calculations that we think might have some unintended penalty consequences that EPA may not have considered. So we're tracking that closely to see how penalties might play out in this space. We've also seen EPA staff, particularly in Michigan, already take enforcement positions that are much more in line with the Obama administration than the prior administration, specifically with respect to regulation of racing vehicles and racing engines and components. And then finally, just wanted to include a note here on CARB. At the end of 2020, CARB issued an alert asking companies and industries to self-disclose any violations of the mobile source regulations prior to the end of 2020. And basically, they provided a warning that after that they would be ramping up enforcement, and we anticipate that they will do so. That brings us to sort of a hot button topic. I don't think I can go a day or even maybe an hour without hearing more and more about zero emission vehicles and the push for electric vehicles. And consistent with other climate change initiatives, there's a number of states, particularly on the East Coast and the West Coast, most notably California, that are considering or have implemented zero emission vehicle mandates. And President Biden has already committed to an all-electric federal fleet. As Pete referenced, CARB has already adopted zero emission regulations requiring all trucks sold in California to be zero emission by 2045. And then Governor Newsom took that a step further in September 2020 when he issued an executive order mandating that CARB develop regulations requiring passenger cars, trucks, and off-road vehicles and equipment sold in California be zero emission by 2035. So we, looking at these mandates and executive orders, certain states might follow California's lead on this, and it may spill over to the national level. With that, I'm going to turn it back to Pete, who's going to wrap up some of the implications for industry from zero emission vehicles.
Thanks, Amanda. As Amanda noted, zero emission vehicles are, in addition to fuel economy, a key topic. I had mentioned that in addition to electric vehicles, California's zero emission vehicles provisions authorize hydrogen powered vehicles as an option. Hydrogen power is, it's a longstanding, it's a well-known source, but the question is, where does the hydrogen come from? We don't currently in the U.S. have an existing hydrogen distribution network that would rival the existing one we have for petroleum. While electricity, we have a grid. We don't have one for hydrogen, and even the source of hydrogen is open to debate. Talk to someone, and they will explain there are different pathways for generating hydrogen for fuel. Gray, blue, or green are sort of the shorthands, depending on whether the source is fossil with carbon capture, or renewable power. So what are the implications? The monitoring and staying in compliance with environmental regulations is key, but what other implications are there for industry in terms of adopting? Obviously, there are supply chain considerations, both for battery as well as potentially for a hydrogen-fueled fleet. In terms of both sets of products are fabulously complicated from an engineering standpoint and may require specific components. Electric motors may require rare earths, and batteries require lithium. There needs to be charging infrastructure for electricity. You basically need to have transmission evaluated to make sure that there's not some kind of impact on transmission facilities in rural areas. Actually have some concerns about charging. And then disposal considerations for batteries. Hydrogen, again, it's a flammable, very volatile gas and requires transmission in basically particular kinds of stainless steel piping. So there are considerations for supply chain and for infrastructure. we do anticipate that there will be additional development for certification procedures for hybrid and zero emission vehicles. And so to the extent that manufacturers or suppliers are working in this space, monitoring those certifications obviously is key to essentially designing components that can meet the test going forward. And finally, a last consideration, this really primarily applies to electric vehicles powered by renewable energy. US EPA has a longstanding process under the Renewable Portfolio Standard, the RPS, for essentially creating credits for refiners to show that renewable fuels are used. There is a process that can apply that to electricity. Because electric vehicles charge directly, RINs are less well developed in the electric vehicle space, and that is potentially a green attribute that could be used by vehicle manufacturers depending on as this infrastructure is built out going forward. So I think in closing, we should anticipate, lower emissions will be key, and an expectation that vehicles are cleaner both from an emissions standpoint and they use a greener chemistry going forward. And with that, I will hand things over to Mark for questions.
Great. Thank you, Pete. What stumbling blocks do you anticipate to arise with the current administration's push for zero emission vehicles?
Yeah, thanks, Mark. In addition to, some of the items Pete mentioned, all of which are manageable related to, supply chain issues and scarcity issues for precious metals that are required for, lower emission type components. Like we've seen in the past with other pushes for alternative energy, such as biomass and ethanol, we anticipate that environmental groups are going to challenge whatever rules the agency puts out as being too weak and not as stringent as they would like. So there'll be some challenges to the rules, we think, no matter what. And in addition to those supply chain and cost issues, some of the infrastructure issues that Pete mentioned with respect to setting up charging stations, making it widely available, and then just making sure, waste streams are managed as we create more battery wastes and things like that.
Great, thank you. And what specific actions can companies take to prepare for a shift to more zero emission vehicles?
Pete, feel free to jump in too if you'd like.
Sure, and I think Mark and Amanda chime in here, but I think sort of identifying the critical path components as well as sort of building out the entirety of the life cycle of the chargers or fueling equipment, and understand who will a supplier partner with, what standards are you designing to. So just mapping out to a greater degree than potentially you would have to, given the existing petroleum side of the equation, how will your vehicle be fueled? If it's an electrified vehicle, what's going to happen to the batteries when they wear out, as Amanda had alluded to. Amanda, other thoughts?
No, I think that covers it. Thanks.
Okay. And lastly, how can companies engage with the agency to understand enforcement positions and initiatives under the new administration?
Well, certainly, I think it makes sense that with most of the EPA staff in this area being out of Michigan, just building relationships with staff members there to understand enforcement positions, working with council or other groups to work with the Office of Enforcement Compliance and assistance at EPA at the headquarters level on enforcement positions and rulemakings, and working with trade groups on different rules and policies that EPA is putting out, I think makes sense. Any other thoughts on that?
I think you've covered it. And we can facilitate some introductions, but I think those are key considerations.
Great, good advice. Well, thank you, Amanda. Thank you, Pete. Next, Shannon Meeker has a CLE announcement.
Thank you, Mark. At this time, I will announce the CLE code. For those seeking CLE credit today, please type the following code into the box on your screen and hit the Submit button. The CLE code is W8FJ8. Again, that is W as in Walter, the number 8, F as in Frank, J as in Joe, and the number 8. We will leave the box open briefly. Once more, the CLE code is W8FJ8. Thank you. And now I will turn it over to Chris Gregorian to continue today's program.
Thanks, Shannon. Hi, I'm Chris Gregorian. I'm a partner in our DC office. I lead our NHTSA and motor vehicle safety practice, and we represent vehicle manufacturers and automotive suppliers on all matters related to NHTSA. So safety recalls, compliance with safety standards, investigations, Tread Act compliance, and the like. So now we'll spend a few minutes discussing the NHTSA regulatory and enforcement landscape. We'll start with a look back. We'll start with a look back at the prior 4 years to see where we've been over that period of time and where we are now. Next, we'll discuss what we might expect going forward under a Biden administration. And then we'll close with some recommendations on what manufacturers can and should do to minimize their compliance risks going forward. First, the conventional wisdom is that government enforcement tends to decline during Republican administrations, leading some to assume that the previous administration might have been lax in enforcing NHTSA's vehicle safety regulations. But the data is to the contrary, as we're about to see here. First, let's take a look at the level of voluntary recalls that have occurred over the last 4 years. As you can see from this bar chart, the number of recalls has remained fairly steady from the prior administrations into the Trump administration and into the last year. It remained, in fact, remains much higher than it was in the much earlier years. Next, we'll take a look at this chart. This shows the quantity of vehicles that were recalled during that same time period. Again, you'll notice the number of recalled vehicles remained quite high over this last several years, as indicated by the blue bar on this chart. And note that prior years reflected several very large recalls, such as the GM ignition switch and Takata airbag recalls. But what's most interesting about this chart is the number of vehicles covered by so-called influenced recalls, and those are shown with the red bar. These are recalls that were voluntarily initiated by manufacturers, but followed a NHTSA investigation. So these figures indicated that there was quite a robust, at least in the last couple of years, enforcement activity leading to quite a few recalls and recalls of quite a few number of vehicles. Next, here's a snapshot, a one-year snapshot of owner complaints submitted to NHTSA, as well as a one-year snapshot of defect investigations. So as you can see from the VOQs, there are about 60,000 owner complaints submitted to NHTSA over the last year. And what's important here is that these provide a very, very robust data set for NHTSA to initiate defect investigations. Many investigations are actually initiated based solely on owner complaints that come into the agency. And then as you'll see in the chart below, the number of investigations, other than a light quarter earlier last year, has remained actually quite steady. And in fact, as of January 31st this year, there were 60 defect investigations still open at the agency. That's quite a high number, historically speaking. And then next, we've got a chart that shows the number of compliance tests that were conducted over the last year. And despite the pandemic and the lockdowns, you can see that NHTSA's compliance test program was actually quite active. The top line shows the number of equipment tests that were conducted. The next line shows the number of vehicle tests that were conducted. The equipment tests involved mostly lighting and tires, brake fluids, and other items of equipment. And then at the bottom of this chart is another interesting data point. It shows the number of inquiries that the Office of Vehicle Safety Compliance received from Customs and Border Patrol. And this is important because it shows the level of cooperation between NHTSA and Customs in enforcing the agency's regulations at the border, and including blocking the importation of non-compliant product. Next, NHTSA's civil penalty enforcement authority was exercised quite robustly in the last 4 years, and these are just a sample of several significant civil penalties that were imposed on major vehicle manufacturers, ranging from $20 million to $140 million over the last couple of years. In fact, NHTSA even engaged in some enforcement against automobile dealerships who were caught selling unremedied vehicles to consumers. So beyond recalls and enforcement, NHTSA's research and rulemaking teams were also quite active over the last administration. In the area of autonomous vehicles, for example, NHTSA published its Automated Vehicles 4.0, ensuring American leadership in automated vehicle technologies, call it AV 4.0. This document was published last January and was the fourth in a series that were published over the preceding years. It outlines the efforts across 38 federal agencies and departments and provides high-level guidance to federal agencies, innovators, and all stakeholders on the U.S. government's posture towards AVs. But also in the AV area, NHTSA published several advanced notices of proposed rulemaking, proposing to amend existing safety standards to accommodate manufacture and deployment of automated vehicles in the U.S. fleet. So we're still a long way off. An ANPRM is still an early stage in the rulemaking process, but the agency showed significant progress towards adopting revised standards. Other rulemakings over the last few years that are quite important to certain sectors of the industry are adaptive beam headlamps, allowing manufacturers to incorporate adaptive beam frontal lighting in their vehicles. And also a rulemaking that would, if adopted, would allow installation of camera monitoring systems in place of vehicle mirrors under FMVSS 111. And then one other one was a requirement to install rear seatbelt use warnings, and that was a congressionally mandated rulemaking. In the area of cybersecurity, NHTSA published fairly recently a new set of cybersecurity guidelines. And in the area of exemptions, NHTSA took the step of granting an exemption to a passengerless vehicle manufacturer, Nuro, that would allow it to deploy completely driverless vehicles for delivering products. And interestingly that was actually not as complex a petition because that vehicle is actually a low-speed vehicle and it's subject to fewer safety standards to begin with. But General Motors submitted a similar petition for its Cruise vehicle, a much more complex full-size vehicle that would carry passengers. That poses much more difficult challenges for the agency in evaluating crashworthiness and crash avoidance standards. But GM withdrew that petition end of the year last year and indicated that it would be submitting a new petition for a different vehicle. So we think that will be an early indication of how the new administration will deal with automated vehicles in terms of how the agency handles that petition. So looking ahead, starting with Pete Buttigieg's confirmation hearing, he didn't really provide a lot of insight into how what safety areas he will focus on during his tenure as DOT secretary. But he did offer a slight glimpse. He acknowledged the safety benefits of automated vehicles, stating, quote, automated vehicles can make people safer. And he expressed enthusiasm for the opportunity for autonomous vehicles, and he wants America to lead the way. He agreed to support and inform legislation that would provide for safe testing and the deployment of highly automated vehicles. And regarding electric vehicles, he recognizes the need to take steps to expand electrification, and he has committed to pursuing Biden's goal of adding 500,000 charging stations around the country. Looking more at NHTSA's personnel, Steve Cliff was appointed the acting administrator of NHTSA. Steve was the deputy executive officer at the California Air Resources Board, which reflects Biden's focus on climate change. And Ann Carlson was appointed the NHTSA chief counsel, and she was an environmental law professor at UCLA, and her primary focus was climate change and air pollution law and policy, again, reflecting a focus of this administration on the environment, fuel economy, fuel efficiency standards. So what can we expect at NHTSA going forward? Well, there's a lot of unfinished business in the area of AV and ADAS rulemakings. So we would expect and hope that the agency focuses on getting some of these early stage rulemakings over the finish line. So for example, most recently, NHTSA's deputy administrator under the prior administration signed a final rule that would amend portions of the 200 series safety standards. Those are the crashworthiness standards, to remove barriers for AVs that lack traditional manual controls that are necessary for human drivers. So we hope that, I should add that that was not published in the Federal Register before the administration left office. And so that's been held in a state of suspense. The agency will review that and hopefully push it through to the Federal Register so that it can work its way to a final rule. Likewise, updates to the New Car Assessment Program, or NCAP. NHTSA released an unpublished Federal Register notice back in January, I believe that was, that would have requested comments related to proposed changes to NCAP. And it would have focused, and hopefully if it's published, it will focus on pedestrian automatic braking, lane keeping support, blind spot warning, and blind spot intervention. And then also seeks comments on NCAP procedures for other ADAS functions like forward collision warning, lane departure warning, crash imminent braking, and dynamic brake support. Another rulemaking that didn't make it over the finish line before the end of the administration is a proposal to provide a special exemption for manufacturers of non-compliant vehicles for research and demonstration purposes. This was a highly sought exemption for many automotive suppliers because under the current statute and regulations, there are significant barriers for domestic manufacturers of vehicles and equipment suppliers to put driverless vehicles or non-compliant driverless vehicles on public roads to accumulate data for testing purposes. So this would create a new regulation, Part 589, to enable manufacturers and other entities to seek exemptions for that purpose. We're also hoping that some of these other FMVSS-related rulemakings will make it over the finish line. So as I mentioned earlier, adaptive beam headlamps and camera monitoring systems are some that seem to be near the finish line. So hopefully this new administration will get those published. But we should note there are about 60 rulemakings listed on the fall, what we call the unified agenda, which is the list of agency rulemakings that are pending at various stages. So it's quite a workload right now. And so we're hopeful that, that the agency will make its way through some of those. Although the spring rulemaking list will be out in the next couple of months, and we expect to see maybe a reprioritization of some of those rulemaking initiatives. Regarding enforcement, well, as I said, enforcement has been pretty robust over the last few years. So we would expect to see that continue. And we also have observed NHTSA using more enhanced data tools for mining its consumer complaint data and the other data it receives So we will see, I think, more investigations coming out of those efforts. As well, the agency is starting to develop a more objective approach to assessing safety defects and deciding when to open defect investigations using things like risk matrices, where they weigh frequency and severity, much like FMEA's process. So we'll see how that might affect the number of investigations going forward. We also think we'll see more strict enforcement of recall documentation requirements. Over the past few years, NHTSA has penalized manufacturers for failing to provide the detailed documentation in their what we call Part 573 submissions as required by the regulations. So we'll expect NHTSA to scrutinize recall documents more closely and penalize manufacturers who perhaps have taken a more lax or casual approach to providing that information to NHTSA. And then finally, I think we'll see even greater exercise of the agency's civil penalty authority. The agency tends to want to send a message out to various segments of the industry. In the past, it was RVs. Recently, it's been heavy trucks. It's obviously been passenger cars. There were some motorcycle penalties a couple of years ago. So we'll see if NHTSA decides, as a policy matter, it wants to send a message to other types of manufacturers going forward. AV legislation is an area that was active a couple of years ago. The Self-Drive Act and the AV START Act were proposed in the House and Senate back in 2017, I believe. Not much has happened in the last year on that. There was some activity earlier last year, but I don't expect to see a very active effort in Congress, at least in the near term, for trying to get that legislation moving forward. So what should manufacturers do to prepare for this next few years? I feel like a broken record when I talk to groups and clients about this, but the key is first and foremost understanding all of the manufacturer's regulatory requirements. So starting with FMVSS compliance. If you're a vehicle manufacturer, you certainly understand all of the safety standards that apply to your vehicle. And if you're an equipment manufacturer, you hopefully understand what standards apply to your products. But one area that gets manufacturers tripped up is sort of production, conformity of production, ensuring that after you do your initial compliance testing, you ensure that your future production continues to conform with the standard based on maybe slight design changes or material changes and the like. Next, understanding your defect and noncompliance reporting and recall obligations that flow from that reporting. Again, very critical that you understand when you must file and how to file and all the various requirements that flow from that. Early warning reporting, which is a quarterly reporting requirement that applies to all manufacturers. Vehicle manufacturers have very comprehensive reporting requirements, while equipment manufacturers have very light reporting requirements, really only reporting fatality incidents. But again, making sure you fully understand what those requirements are for your particular company. The next one, submission of service bulletins. We call this the Part 579.5 requirement. This has gotten many manufacturers tripped up, especially small vehicle manufacturers and part suppliers. This requirement specifies that manufacturers must provide copies of certain external communications regarding defects, consumer advisories, and similar documents to NHTSA on a monthly basis. And then foreign recall reporting requires reporting of any recalls you conduct in foreign countries. And there's some miscellaneous sort of, we call housekeeping types of requirements, manufacturer registration and designation of agents if you are a foreign manufacturer importing documents into the US. So we recommend that companies adopt or at least periodically update their written policies and procedures that cover all these types of requirements. And ensure there's a protocol for identifying, escalating, and evaluating potential safety-related defects in your products or vehicles. And then have a set of written early warning reporting compliance procedures. And then key to all this is the training aspect. It doesn't do anyone good if you've got policy C on the shelf, but key personnel don't understand that they exist or don't understand what they mean. So periodic training for key personnel in various functional areas such as engineering, quality, warranty, legal, service, purchasing, and then ensure that that's part of their onboarding as well as part of their ongoing refreshing training. We do see significant issues, lapses occur when personnel who have been trained in these areas leave those positions, rotate into other positions. Then we have new personnel and they really don't have any understanding of these requirements. And then we recommend that someone at the company be monitoring legislative and rulemaking developments. We've also seen companies get tripped up when some of these reporting requirements changed, but nobody realized it. It happens less often with changes in safety standards, but again, we have seen situations where a standard changes, but no one in the company recognized that, and they're continuing to manufacture a product or vehicle under the prior version, and then end up in a non-compliant situation. And then finally, engaging with NHTSA. Most major vehicle manufacturers are now meeting periodically, some even monthly, with NHTSA's Office of Defect Investigations to discuss various issues that their safety committee may be looking at, or to discuss owner complaints that have come into NHTSA that NHTSA may have questions about. So this industry engagement has been a big part of NHTSA's outreach over the last few years, and I think for the most part it's been very constructive, and it's probably what has led to the high number of recalls we're seeing. If you're a supplier, you're not likely to have these meetings, although some major suppliers do have those periodically, but you'll likely be pulled into some of the issues that come up during those meetings. So be prepared to get inquiries from your OEM customers to respond to questions that NHTSA may have through these informal periodic meetings. So that's all I have for my presentation, and I will turn it over to Mark Aiello.
Thank you, Chris. My first question is, and you touched on this, but can you elaborate on what you see as the key focus areas of NHTSA enforcement efforts going forward?
Yes. Yes, I did. I touched on there are two primary areas. One is never going to change: timeliness of recall decision-making and notification. That has been the basis for the largest civil penalties that have been imposed. And so we think that will continue. And the difficulty there is that the decision regarding whether an issue represents a safety-related defect can be quite complex. And as vehicles become more complex, it might be more difficult for manufacturers to decide if this particular condition is a safety defect. And we see maybe disagreements in the area of vehicle stalls or loss of propulsion, or how many fires or thermal events would trigger an obligation to conduct a recall. And there are disagreements between manufacturers and NHTSA over those kinds of questions. And so as issues become more and more complex, especially when we get into automated vehicles and the decision-making that the software will be making, we think there will be situations where NHTSA will force recalls and penalties when manufacturers don't take prompt action. And then secondly, NHTSA has, as I mentioned, been highly scrutinizing manufacturers' recall documentation and processes. These are after the decision's been made and the notice has been filed. What information is the manufacturer providing to the agency? Is the manufacturer updating that information as new information comes in regarding, say, root cause, or whether there's an updated remedy for that particular condition? As well, the timing of notifying owners. Those are areas that have gotten some manufacturers into trouble over the last few years, and we see that continuing into the future.
Great. My second question, and you mentioned the Self-Drive Act, the AV START Act, as bills that were initiated but ultimately did not pass. Do you see similar bills advancing soon?
I do see it, but maybe not for a while. It's very difficult to predict given the heavy legislative agenda that the democratically controlled Congress has in front of it and its objectives in other areas. But during Pete Buttigieg's confirmation hearing, Senator Peters asked Buttigieg whether he would agree to cooperate with the committee on informing, as he put it, AV legislation. So some have interpreted that as a sign that that there is something imminent, and well after the 2017 effort to get that legislation passed, committee staff had continued to work on those bills as recently as early last year. Things have been quiet for a little while, but it's very possible we'll see something move fairly soon. But it might very well be a slimmed down version compared to what was being proposed a few years ago. And that's primarily because NHTSA has made a lot of progress. As I mentioned earlier, some of the rulemaking that have already started would address some of the issues that Congress had tried to address in some of the provisions of that bill. So it could be a slimmed down version. So we'll see how things look maybe as things simmer down mid-year or later this year.
Okay, great. Thank you, Chris.
Okay, thanks.
Next, we have some questions that were posed, and I'll ask the first one. It's a two-part question and directed to Greg and Jen Lane. What types of issues do you anticipate companies having with implementing USMCA throughout their supply chain, and what are the biggest problems that you see as companies transition to USMCA compliance?
Yeah, let me take that. There's a couple of issues that we see coming up over and over again. The first I mentioned in the presentation is corralling your supply chain. This isn't unique to USMCA. We saw the same thing when conflict minerals compliance came about, that when you send out your certification requirements or ask people to do something, you might get a 50 or 60% response. So leaning on your supply chain to cooperate, particularly if they are being brought in for the first time under USMCA rules and maybe didn't have as big a role under NAFTA, that's a big issue. A second problem is there's so many gray areas. The customs regulation or guidelines that came out in mid-2020 are helpful, but they leave a lot of gray areas, particularly with regard to the regional value content calculations, which are so critical to determining whether or not you meet the requirements. And again, those have to be applied throughout your supply chain. The third issue that comes up is engineering and rejiggering the amount of content that's originating within Canada, Mexico, and the United States. Because a lot of companies had fine-tuned under NAFTA to just exactly meet the requirements, and now the thresholds are going up. Plus, there's a lot of specific automotive areas. And then the fourth one that comes up is engineering this in the backdrop of the Section 301 tariffs, because if you're bringing in goods from China to, say, Mexico, and then you're adding further value, the question is, are you doing enough to turn those goods into products of Mexico? And unfortunately, the test that customs uses is a substantial transformation test, and it's different from the tariff shift-based test and the specific automotive regional rules that are in USMCA. So balancing the need to minimize the Section 301 tariffs at the same time that you're trying to meet the USMCA tariffs can lead to a more complicated puzzle. So I think those are the key areas. On the plus side, the labor rules don't seem to have been quite as problematic to implement as people had thought, but a lot of companies are just getting into that, and its impact will depend on your unique business profile. So that's also a potential problem as well.
Great, thanks, Greg. The next question directed to Jeff and Felicia. do temporary workers placed and employed by a staffing agency have to pass the ABC test in order to avoid employment relationship?
Sure, and I can address that question. Typically, employees that are employed by a staffing agency and on-site, the analysis of whether there's a joint employer relationship is slightly different than the analysis of whether they're an independent contractor or an employee. And typically, it is similar in the sense that you're sort of doing an analysis of the facts on the ground to determine when there's a joint employer relationship there. The ABC test is focused on the independent contractor versus employee relationship, so that one doesn't apply. But there is a test that's done that analyzes the control that the employer has over the employee, whether they have power to hire and fire the employee, and whether they're being supervised by the employer's supervisors. Often what we see is when there is a staffing company and temps that are on site, there is often a joint employer relationship because a lot of times they're working side by side with your employees, and either team leaders or supervisors that are your employees are supervising their work, and you do have some control over their work. So often we do see there's a joint employer relationship there. There are occasions when there isn't, but that's really where we see that most often is sort of a third party, maybe quality team will come in at the end of your process and check quality, but they have their own supervisors and their own processes, and they're really not reporting up into the company at all. So it depends on where these temps are working and who's supervising them. It's different from the ABC test, but there is a joint employer test, like I said, that focuses really on the facts on the ground of who's supervising the employees and what control the employer has over those temporary workers that are technically employed by the staffing agency.
Great, thank you, Felicia. Next question, directed to Amanda. How do states develop regulations which exceed the federal rules under the concept that they affect interstate commerce?
Yeah, so with respect to emission standards specifically, California is able to enact stricter emission standards under Section 209 of the Clean Air Act. So Congress specifically allowed California to obtain a waiver from EPA to enact stricter emission standards. So that's how California does it. And then, you know, other states under Section 177 of the Clean Air Act can then adopt California's standards. So that's sort of, you know, California starts out that process with setting stricter standards, and then other states can, you know, follow California's lead. So that's how states can implement stricter standards than the federal level. Another note then, I know we touched on refrigerants a little bit when we were discussing our portion of the environmental section. And some states have taken the position that they're enacting their own bans or regulations for refrigerants and saying that there's no preemption because the standards aren't stricter or there's no federal preemption. So that's sort of how some states have been addressing this and creating different standards from the federal level.
Great, thank you, Amanda. Next, I think Greg is going to handle the wrap up. No? Well, that is it for all of our questions. And
no, I'm
Greg,
sorry about that. I was looking for the right buttons. Thanks for that, for those questions, Mark, and for the audience for putting those questions in. And of course, thanks to the presenters and everyone who joined today. If you have any follow-up questions, then please feel free to reach out to us. I know that sometimes issues come up that people wouldn't want to air in a public place, or that they feel are very, very specific to their companies. So all of us are hoping that this is the start of the dialogue rather than the end of the dialogue. So if you want to reach out to any of the presenters to follow up, then feel free. Also, I should mention before we wrap up that we have our annual automotive white paper that's coming out. We're releasing it today, and it has 10 comprehensive articles that dig into the key trends, not only that we discussed today, but other trends that companies in the automotive sector should be mindful of for the coming year. This is a very popular document that we've been doing for years and then that we update annually. And if you want to download a copy, you can look at the resource list that's on the right-hand side of your screen, and you can download it. Or if you're having trouble doing that, then you can email any of us, and we'd be happy to get it to you. In addition, we will also be releasing a couple of new white papers in a couple of weeks, one on dealing with the international trade war, which we're updating for the new administration, and one on dealing with best compliance practices on the international regulatory front. So we will be following up with both of those as well. So you should be on the lookout for those topics because we know that a lot of companies are international in the automotive sector. So this is something that we've been doing for the last couple of years and has also proved very popular. So again, this is the proverbial tip of the iceberg. We would be happy to continue the dialogue for anyone who has any further questions you might think of as time goes on, or if you just want to arrange a one-on-one call, let us know. Otherwise, thank you for the time. Hope you enjoyed the presentation and that everyone has a great rest of the day.
Thank you, everyone.